Let some people come in the room. Some people going. Last night we had about 4,000 people streaming our debate commentary.
Oh, that's awesome.
Yeah, it was really good. I'm going to send you guys the link here to share the show as people start coming in. See, copy link. People start coming in, start watching. Everyone, welcome. There we go. Are you guys hearing a feedback loop on your end?
No.
Or is it just me? Okay, it might just be me. And um, hearing a feedback loop on your end?
No.
All right, I think I got rid of the feedback loop. We're live on YouTube. Everyone, welcome. This is kind of just a CrossPolitic live talking the SCOTUS rulings. Particularly, we're going to be talking about the Chevron ruling. It is quite the ruling. I think this is going to have some pretty significant implications to the bureaucratic state. I got Caleb Bird and Davis Yuntz on from the Yuntz law firm, and we're going to talk about this Chevron ruling. It really has significant implications on the administrative state, particularly. I am, if you are following me also on Twitter, maybe Davis is already tweeting this out too, but you can find the SCOTUS ruling on my Twitter thread. You can find there's a number of actually rulings that have come out today. Some of them not as significant, but there's a lot of SCOTUS movement happening. I don't know if you guys also captured the SCOTUS ruling regarding Twitter, the Twitter files, basically, with in Missouri. That is another. I think that's a crazy ruling. Is a travesty. We'll maybe talk a little bit about that too in this. But as people are coming into the room, we're going to talk about the Chevron ruling, particularly, and then maybe we'll get into some of the Twitter file Missouri SCOTUS ruling that happened last week. Davis, while people are coming in the room, how do just maybe recap a little bit, actually, all the SCOTUS rulings that have happened, and maybe just hit on what they've kind of gone through this June so far, if you can kind of recap, or maybe Caleb, you might be able to chime in here too.
Hey, Caleb, if you want to take the lead on that, I have some more kind of overarching things that I can say about what to expect. But the biggest thing people need to understand is this is common for June. Supreme Court's about to go on their recess, so this isn't like a surprise. So every year it seems like, and I know I used to feel this way even in law school. I was like, okay, why all of a sudden is every important case in the world coming out in June? Well, the answer is every case decision is being released in June. It's just one of their most common times to release cases. They do often save significant rulings for June. It's because they're about to go on their summer break. So this is kind of when they clear their docket. So that's what's happening here. It's not timing. It's not trying to do an election or anything else. That part is common. This is what they do in June.
Is it common? I mean, because it seems like they leave their best for last, or whatever you want to call it, their most controversial, episodes for last, or rulings last. You know what I'm saying, Davis?
Oh, that is that's very common. That seems to be a pretty significant part of the process and what they do, at least what they've done the past few years. That's a fairly common thing for them. Yeah.
Interesting. Caleb, do you? I know David had surgery just days ago, so he's still recovering. Caleb, do you have a list or kind of just have a quick overview of some of the rulings that have happened in June besides what we're going to talk about today with the Chevron ruling?
Sure. We've had a couple of really important cases. The Murphy v. Missouri case that came out regarding government influence of social media and how it relates to government coercion. That was an interesting case that's come out this June. You have the ones for today. Obviously, the Supreme Court historically has always done a really good job of building up the suspense for the big cases. If you remember, even like, for example, Dobbs, the Obamacare decision, Obergefell, when those come out on like the last day of the term. They fire those out, and then everybody goes home. The Jarksy case that came out, I believe it was this week. That one is also fascinating in the way it affects administrative law, along with the Fisher case that came out today related to January 6th and how certain criminal statutes are going to be interpreted. So it's been a very, very busy. And even Moyle, which is out of Idaho, strange decision, but this has not been a slow June. Which the fact that we're in an election year, the liberals continue to try to put the Supreme Court under a lot of political pressure. The fact that we're still getting some huge earth-shattering cases in a June of an election year, I think is very important. So there's a lot going on. There's a lot happening. It's hard to keep up with, but like today is frankly just a whole lot of fun.
Yeah. So, do you think there are in the next couple of days going to be more Supreme Court rulings released, and do you think they're going to get more controversial? I mean, is it ramping up for the last, before July?
I would have to double check the court's docket to see what all is left. Here at the end of June, we typically everything is finished up over or prior to the 4th of July. Very rarely, if ever, do we see anything that's going to go beyond that. But I would have to double check the court calendar to figure out if they have any more cases that are still pending out there.
Yeah, Gabe, since I've been in the hospital, I haven't been looking at the docket. Typically this Friday, so today, the Friday before the 4th of July weekend, we would expect the final drop typically. Not always, but typically 4th of July falls in the middle of the week. Again, you're thinking summer vacation time for government employees, right? So the Supreme Court and all their employees are government employees. So they're going to take advantage of the government holidays, if nothing else. I think trend wise, when you look at this session of the court, what's really, really interesting is it's a pretty divided court, but it's not divided in the way that mainstream media or most people want to divide the court. The court is divided into three sections. Okay. This is how I describe the.
You mean like Justice Alito, Gorsuch? They're all divided basically in three kind of groups.
They're in three groups. There's three teams at the Supreme Court. So you have Alito, you have Thomas and Gorsuch, which are one camp of three. Then you have Roberts, Kavanaugh, Coney Barrett in one camp, and then you have the quote unquote progressive or liberal justices, right? And so, they are all that's what's so fascinating about this. Why? What are those three camps? Again, if you're looking at, aside from criminal law, set a criminal law case aside for a second, and we can talk about why those are a little bit different. But in every other case involving state authority, federal government authority, government against the individual, expansion of federal powers, or anything else, expect the liberal progressive justices to be together and moving in one direction. As far as the centrist judges, if you will, and I wouldn't really call them centrist. I would just call them like pro-government, generally speaking, Republicans. That's really what they are. When you look at Roberts, Kavanaugh, and Amy Coney Barrett, they seem, Roberts as a political operative as a Supreme Court justice in some respects, because he seems to care tremendously about the political fallout of decisions all the time. So if there's
that's a good point.
Right. So if there's a middle ground compromise, appeal to the middle road to find that's very practical, that seems to be the three you can count on to sort of move in that direction. And then the other three are fascinating. I think that Thomas is a true constitutional scholar, a true federalist, strict constructionalist, believer in the Constitution, but also a believer in God and higher powers, and understands the foundation of the Constitution, which has turned him into an incredible Supreme Court justice. Alito is often in that same camp, seems to be influenced by faith, seems to have a clear understanding, not just of the Constitution itself, but of many of the principles underneath it. And then Gorsuch is fascinating to me. He's intellectually brilliant, but he's the closest thing to a libertarian I think we've had in the Supreme Court in a long time. And when I say libertarian, he really does lean that way. He's not, and so that's where you see incredibly good decisions from him, decisions that are very well thought out, decisions that might even be otherwise politically unpopular or an issue that nobody cares about, but he'll put a tremendous amount of effort into that decision, into writing that decision, into lodging it out if he thinks it's important from a freedom, liberty, Constitution standpoint. At the same time, he will go off the rails on moral issues sometimes, right? So he will not have a moral foundation to some of his rulings. So he might be on the wrong side of, gay marriage issues or other things when he makes his ruling. So that's what's fascinating about him. But right now, it really is. I picture it this way. It's probably not that way at all. But I feel like, if you we're walking around the Supreme Court building with no cameras and you're just there, Gorsuch, Alito, and Thomas would be hanging out, sipping bourbon, smoking a cigar. I don't know if they drink bourbon or smoke a cigar or not, in one corner of the room, right? In one corner of the room. Alito, Roberts, and Kavanaugh would be huddled around watching Fox News or CNN constantly. And, the three progressive justices would be watching something else, or, talking about critical race theory or something else.
I might have missed it, but what group do you think Barrett might be in?
In that middle group.
Okay. And you're saying that middle group is just like some sort of maybe traditional conservatism in how they read the Constitution?
I wouldn't even say traditional conservatism. I would say modern Republican.
So let's talk about the Chevron.
And I don't want to say this. Yeah. I just want to why I say that. Just, they sometimes seem to be outcome driven rather than strict constructionists, right?
Right. So
strict constructionist is, this is the Constitution, this is the law, this is the principle. We're going to follow it. Consequences be darned. Those three, they will find a political compromise to get to what feels like a good outcome. Not always. They make some great decisions. They do some good things. But that just seems to be the tendency right now when you look at the grouping of the Supreme Court.
That's really helpful. Those three groups and categories are very helpful. So let's talk about the Chevron ruling that just dropped today. So SCOTUS just ruled 6-3 or 6-2 and one. It was something. What I read was it was like 6-2, and then there was one who, So anyways, I'll have you describe that in a minute. But SCOTUS just ruled today on the Chevron ruling, and as I understand it, the Chevron ruling kind of dates back to, the 1940s, 1950s, where basically the courts ruled that the administrative bureaucratic state had the ability to make up their own regulations outside of Congress, and that They've been doing that for a long time. But that Chevron had to kind of submit not only to their own rules, but to their own, let's say, kangaroo court within the administrative system. In other words, you guys can correct me in all this. I'm going to talk, plain Jane language, common language first. You guys can correct me. In other words, if Chevron didn't like an administrative rule and they appealed it, they'd have to appeal it with the bureaucracy, and then the bureaucracy becomes kind of judge, jury, and prosecutor, and then Chevron has to submit to the bureaucracy's judge, jury, and prosecutors outcome of that administrative interpretation. So correct me where I went wrong.
Yeah, yes, no. And what I'll do is I'll kind of give big picture Chevron doctrine, and then I'll let Caleb get into the details and talk about this case. But the Chevron, it's literally the company Chevron. That's what this case is about.
That's right.
But what we have seen in our nation, just unprecedented, really, and it's hard to say when it started. It probably started most painfully with Woodrow Wilson, followed quickly by FDR. But this idea was the way to get things done is through the administrative bureaucracy. So the most powerful part of our federal government are the federal bureaucracies, the alphabet agencies, all of that. And so what the Chevron doctrine was, this legal principle that gave these federal agencies just huge swaths of authority under a specific law. So Congress has really gotten into the terrible habit of passing a law that's written. I mean, and this is how it works. Let's say you work for the EPA. The EPA says, we should have a law dealing with, let's just keep it simple, clean water, right? So the EPA says we're going to have a clean water bill and it's going to impose these restrictions on companies. The EPA itself, they'll write the bill. They'll send the bill to Congress. Congress will review it, work on it, make changes, edits, go back and forth. There'll be a lot of lobbying, all the stuff that happens on a bill. And then Congress will put out a bill that is very, very bare bones, typically. And then the agency has just tyrannical authority, really, to issue implementing regulations. And then they also have the control. So if you don't like their decision, that's going to shut down your company, make you unprofitable, make it you incapable to continue to have a ranch or whatever it is. The Chevron doctrine says, well, the courts aren't getting involved until you've exhausted all administrative processes. And then even sometimes, well, that's the only recourse that you have. That's the system that's set up without ever really going back to congressional intent or other issues. So that Chevron doctrine is part of what has allowed this out of control federal bureaucracy that they have in our country. So when we think about a case that says, hey, the Chevron doctrine is gone, we should first of all say, praise God, and say, okay, where's the litigation? Where's the lawsuits? Let's go. And which federal agencies do we not need anymore, right? Like that would be what I want to be start talking about. So that's kind of big picture. I'll let Caleb get into some of the details from the case.
So Caleb, this ruling, it's been a 60, 70-year doctrine at this point. Walk us through how this got challenged, or who challenged it, and under what basis it was challenged.
Okay, so the Chevron case was decided in 1984.
Okay, I thought I heard 50s.
So this is a long downstream issue, really coming out of, as Davis explained, Woodrow Wilson, the New Deal era expansion of the administrative state. Okay. So in this particular case, the court struck down the Chevron doctrine and said, going forward, courts do not have to defer to the administrative interpretation of its own regulations. So if you want to take a step back, here was the issue previously in Chevron. Under the Clean Air Act, Congress gave the EPA the authority to regulate the source of air pollution. Okay. And so the problem was Congress did not define what source meant. So this becomes a huge problem. Congress does not define what a source is, And the EPA is now trying to impose penalties through regulation onto Chevron for being the quote source of pollution. Okay. And so what the court in 1984 said is when you have Congress passing a statute that has ambiguous language, the court has to defer to the administrative agency's definition for what the ambiguous language is. Now, first of all, if you just take the 30,000-foot view, this creates a huge problem because, you know, as Wilson is fond of saying, our war today is a war over the dictionary.
Yeah.
Well, if administrative agencies can continuously reinterpret what words mean, then words are meaningless. Now, Article 3, if you go back to basic fundamental American legal jurisprudence, Marbury versus Madison, Justice John Marshall said it is emphatically the providence and duty of the judiciary to say what the law is. This is fundamental to Article 3 of the Constitution. The judiciary interprets laws. But what Chevron did is say that the judiciary does not have the authority to interpret what a statute means if the statute is ambiguous and an administrative agency has said that this is the definition we're going to apply. This has been a plague on American society since 1984.
For real. Yep.
And the court has slowly been chipping away at this doctrine. And what the court did today was, it's really interesting how they did it. Thomas and Gorsuch really go into this in their concurrence to the opinion. The main opinion does touch on Article 3, but spends most of its time talking about the conflict between the Administrative Procedures Act and Chevron Doctrine, right? So the Administrative Procedure Act puts the Administrative Procedures Act was passed in I think like 1946. But what the Administrative Procedures Act did was it said, this is how we're going to handle it. It created the framework for administrative law. And under that framework, the courts have the authority under this statute to interpret both statutes and administrative regulations. Whereas Chevron in 1984 turns that and flips it on its head in violation, this court found today, in violation of both the Administrative Procedures Act and Article 3 of the Constitution. Now, this court spends the majority of its time focusing on the Administrative Procedures Act, which both Gorsuch and Thomas point out, hey, we don't even have to get to the Administrative Procedures Act. This is a direct violation of Article 3 of the Constitution and foundational American jurisprudence in Marbury v. Madison when it comes to the role of the judiciary and ceding authority from the judiciary over not just to the executive branch, but to administrative agencies within the executive branch.
So what is that? So basically, this SCOTUS ruling says that the administrative agencies do not have the authority to create their own definitions out of thin air.
So let me start with the more important definition. What this means, overturning the Chevron Doctrine re-empowers the court under its inherent judicial authority to interpret laws and statute. They do not have to depend on agencies to do it. They do not have to defer to agencies to do it. And so what this means is that when a court comes in and says, this is how I interpret the statute, whatever the agency thinks about that interpretation is no longer binding on the court to be able to implement what the court believes the statute says. So that's where it starts. So really what this does is it doesn't necessarily prevent an agency from interpreting ambiguous language. What it does is keeps that interpretation from being binding on a court of law.
Interesting. And
So
so the courts don't have to work within the administrative framework. They can work
That's right.
within the constitutional framework and judge based off the constitutional framework and not what the framework that the bureaucracies have created in house.
And let's talk about another reason why this is very, very, very important. There are fundamental rules of statutory interpretations. You can think of it almost like a legal hermeneutics, right? There is a way that we read statutes, okay, starting with the plain language of the statute. And this is something Scalia was huge on. We don't go look at congressional intent when the statute is plain, and we use plain meaning at the time that the statute was drafted. Okay. So if you're applying proper statutory interpretation, if there is ambiguous language, the law says tie goes to the runner, right?
Yep.
So the defendant in a case, if the language is ambiguous, gets the benefit of the doubt because they're the ones facing criminal and civil penalties. Congress has a duty to be explicit and clear with their laws. So this is fundamental. This applies in criminal law, civil law, bankruptcy law. If there's
Yep.
a statute, this is how we do statutory interpretation. Here's the problem with Chevron. Instead of saying, as we do with all other laws, tie goes to the defendant, what Chevron did was tie goes to the bureaucratic agency seeking to enforce the statute.
Yep.
but
And
even worse, the court could present a case to the court, and it really doesn't matter. There's a lot of different examples. Think of anything that the federal government regulates on your property, in your business, or anything else, and that's where it
Yep.
comes in. But under Chevron, as long as the interpretation of the meaning of a word like source was deemed to be not directly contradictory to the intent, to not be so absurd as to be completely unjustifiable, you're going into court to challenge a federal agency that's doing something that may end up taking your business or your land or otherwise because they have defined an ambiguous term in a certain way. The court was supposed to give deference under the Chevron Doctrine to whatever interpretation the administrative agency came in. So it's
Right.
like you're suing the EPA over the use of a word, right? And the way that their
Yeah.
regulations come from the word and what they're defining as a wetland or a source or whatever it
Yeah.
might be. And then the court's going to go, okay, we understand how there is a logical way to read the congressional statute. And quite in many of these cases, what was deeply troubling is you would have courts that would say all the time, yeah, we are very sympathetic to the landowner that's losing their family ranch, or we're very sympathetic to this business,
Right.
right? We're very sympathetic, but under the Chevron doctrine, the agency is allowed to define these ambiguous terms and they haven't abused their authority to do so. Therefore, agency wins.
So
And Caleb,
how many rulings or atrocities do you think this actually ends up overturning?
so that's going to be the issue about whether the court goes back and starts reapplying Chevron doctrine to previous cases. That's going to be extraordinarily hard to do because there are thousands, literally thousands of administrative, district, appellate, and Supreme Court cases that have been decided against defendants under the Chevron doctrine since 1984. And so to say that it would be a nightmare to go back and try to unwind all of these cases, it would be an understatement. However, going forward, this is a huge win in the battle against the administrative state going forward.
Why wouldn't they go backwards? Are you just saying it's all moot point kind of thing? That's how the courts would rule it. Hey, this was what it was then, and now it's changed. This is what it is now. Is that going to be kind of the argument in the courts?
Yeah, generally when the courts create a new rule of interpretation, right? Or in this case, they get rid of a bad rule of interpretation. It's not going to apply retroactively, right? That is because courts are supposed to apply the law at the time as they're going through. And so retroactive application of law, even in the administrative law sense, is generally something that the court is not going to permit.
Mm-hmm. Incredible. What so does this ruling also, I mean, it seems like it really weakens the administrative state. Does it have any impact on actually getting rid of the administrative state, if that makes sense? That's what I
So
want.
So this goes back to Davis's discussion earlier of kind of the 3-3-3 split on this court is very interesting. If you look at, if you want to call them the middle three, Roberts, Kavanaugh, and Barrett, they're really not centrist. They're really on the right-hand side of legal jurisprudence. But one of the things that I think characterizes that group is incrementalism. Um, Roberts has even said publicly before he does not like to pass rulings that make sweeping changes all at one time. Like for example, in one of the earlier cases, Jarksy, the Supreme Court has continuously chipped away at the Dodd-Frank Act that was passed during the Obama administration, instead of just ruling the whole thing unconstitutional. Right? We saw this with the Dobbs decision. We finally get Roe overturned after the Roberts Court had slowly chipped away at this thing for over a decade. And even then, even in his concurrence, Roberts said, "Hey, look, I don't think we needed to overturn the whole kit and caboodle with this case. We could have continued to chip away." And so, really, the thing that needs to happen at the Supreme Court is a reinstitution of the non-delegation doctrine. That's what this is slowly working towards. And right now, I really do think we have 3 justices on the Supreme Court who, given the opportunity, would reinstitute the non-delegation doctrine. And here's why this is important. Chevron is irrelevant under a non-delegation doctrine.
Right.
And if you look at the concurrence from both Thomas and Gorsuch, that's really what they're getting after in their concurrence is, look, we don't even need a Chevron doctrine. We don't even need to get into how administrative agencies interpret rules and statutes. If we would apply the non-delegation doctrine, this is irrelevant. We don't even need to get into this at all. But what we're seeing is the slow chipping away of the administrative state, when really what we would really like to see the Supreme Court do is go out back and old yeller this thing.
Right. So spell out for me what is the non-delegation doctrine?
So the non-delegation doctrine is a constitutional principle that was largely adopted by the Supreme Court until the New Deal era. And so the non-delegation doctrine says the Constitution of the United States has created executive, legislative, and judicial bodies under the relevant articles of the Constitution. Those separations of power are actually separate. The executive has executive authority, the legislative has legislative authority, the judicial has judicial authority. Under non-delegation doctrine, the Congress cannot delegate to the executive its own authority. The executive cannot delegate to the judicial its own authority. And what you start getting in the New Deal is the abandonment of the non-delegation doctrine. And that has been the fuel that has powered the administrative state since Wilson, and then especially in the Roosevelt era. Because what Congress was able to do was delegate the vast majority of their legislative authority to unelected bureaucrats in the executive department to create rules, to create laws, to create regulations that impact Americans both civilly and criminally. This is, to put it mildly, one of the greatest attacks on the Constitution that exists in American jurisprudence today. It directly undermines the separation of powers created in the Constitution.
Right.
And Chevron doctrine was it expanded the scope of that, but Chevron doctrine was only ever applicable in a system in which the legislative body was allowed to delegate its inherent authority to a different branch of government.
Davis, any follow-up on that?
Yeah, so I would just want to follow up on the practical aspects of what this does in near term. when you talk about losing the Chevron doctrine. This really does give individual citizens, this gives states, this gives corporations an ability to push back against federal bureaucracies with a level playing field now, right?
Mm-hmm.
So they can look at a congressional statute, they can look at a regulation that puts out and say, yeah, this doesn't make any sense. This is the administrative state going too far. This is overreach. And now when you challenge in court, you don't have to worry about constantly losing because the court's just going to defer to the administrative agency's interpretation. You've actually got an even shot to win. So if you can look at a law and you can look at a statute and you can argue, hey, my client shouldn't be paying hundreds of $1,000s in fines because this was a really vague wording, a really vague interpretation. They were trying to do the right thing, but it's vague. And where it's vague, it should be read in favor of the defendant, of the individual, of the citizen, not in favor of the government. And if we can get back to that and being able to sue and fight back and push back and having that different standard, that's where getting rid of the Chevron doctrine levels the playing field, gives us an opportunity to get back in the courtroom and win some of these cases that just was not there before.
All right. So knowing what you know now, what strategic cases would you pick up right now?
And there are so many areas of federal bureaucracy that are clear overreach. I mean, honestly, I would want to look for cases. What's near and dear to my heart are cases that involve small businesses, but particularly like property owners, ranchers, water rights, things like that, where the EPA has just come in and crushed family farms and other things. So I would hope that this would open the door for some new litigation on those things and perhaps, open the door to getting rid of some of the really bad case law. Again, to me, I always look at what, simple, basic rights, property rights, things like that, freedom to use your own property, the property that you've earned, purchased, and worked as a family. So those are the kind of cases I hope we could see. Don't know a specific area of the law or anything else, but there's a ton. I mean, there's 40 years of case law under the Chevron doctrine, then goes all the way back to the 40s under the Administrative Procedures Act. But there's 40 years of case law that could be looked at, and every single one of those cases could be looked at, and not every single one would, but every single one could have turned out differently if the court was allowed to use statutory interpretation rather than to rely on deferring to the Chevron doctrine. I mean, think about that, because this is how you interpret it. This is how you make a decision in the court. If you don't have to defer to the federal agency, a whole lot of cases have been decided where the courts have said, well, I don't know that we necessarily disagree and we're sympathetic to you, but the agency interpret it. It's within their legal authority to do it. Chevron doctrine, we're out. Those that actually been reviewed, every case where the Chevron doctrine was applied, not every case would have come out differently, but every case could have come out differently. That's what's amazing about this. So this doesn't automatically fix all the past wrongs, but it does level the playing field. It does give people a better opportunity to actually plead their cases. And, you can work through these. And so that, again, though, I would look at, to me, it would be like water rights, land rights, Bureau of Land Management cases. Some of those things I think would be prime cases to be looking at.
I'll tell you another really good one right now it would also be very relevant, that's been in the news, is the way the Department of the Department of Education has reinterpreted its discrimination regulations in imposing radical transgender ideology on, literally down to the elementary and preschool level, right? If you look at what it was just a couple months ago that the Department of Education pushed out this new interpretation. Well, what this is going to allow is for parents, school systems, states to be able to challenge that interpretation of the law and not have to defer to the Department of Education's definitions of discrimination, for example. So that will be a big one that I think is probably going to, it was already spinning up. This is only going to empower those cases.
Interesting. I'm just trying to think through some more modern examples that like Caleb just gave that this might impact. uh, what? I mean, I wish I had more time to think about that. I know we're live right now talking, but that is a really interesting scenario. I know we had water rights issues, and
Mhm.
I know we had an EPA decision that was overturned by the Supreme Court from out of Idaho, northern Idaho.
Right.
If you followed that case, that scenario, it took this family 10 years, 11 years, 12 years, whatever it was, to get the EPA off their back. Our previous attorney general did not help them. He was horrible. Our previous attorney general had been there for something like 30 years or something, and he was just a bag of jello. And then Raul Labrador came in and took it all the way to the Supreme Court and helped this family against the EPA.
Right.
What about the Bundy and,
Yeah.
Bureau of Land
Yep.
Management? What about, I'm just trying to think of
Yep.
all these famous scenarios where there's I mean, and then you got even like the weaponization of the FBI. Does that play into any of this that's been going on?
So that's a harder one because what the FBI is and the Department of Justice are mainly focused on doing, like for example, like the FACE Act case, the January 6 cases,
That's right.
those cases that are going on, those are actual federal statutes, not merely administrative regulations. But I mean, I was just actually sitting here thinking that the Bundy case would have probably been heavily impacted both by this one and Jarksy, which we can get into in a minute, because I think these two cases combined are really taking a sword to the administrative state in a truly powerful way. Obviously, we want to do more. But I think I can confidently say this has been one of the most important Supreme Court terms in battling back against the power of the administrative state that we've seen in our lifetimes.
So I have a question from Philip. He says, any cases involving the ATF that this would affect?
Potentially, yes.
Potentially.
And again, the reason is the ATF has been given way too much deference in coming up with definitions of things. So think of anything that the ATF is given the freedom to define. Think of words that are used, right? So I'm not going to be able to come up with a specific example. I wish I could on the fly here, of a specific example from gun law. But think of any restriction in a gun law, any aspect of that is left to the ATF to come up with an interpretation of what it means, right? So let's just, let's say, for example, Congress talks about this all the time. Let's say Congress came out and said, we're banning assault rifles. Right?
Yep.
But they don't define what an assault rifle is. Well, then who's going to define what an assault rifle is? The ATF is going to define what it is. And then it's going to be left to the ATF. Are they going to do a very strict interpretation of that? Are they going to do a very broad interpretation of that? And so, there are all kinds of ways we could think creatively about a lot of ways, but whenever Congress has passed or passes in the future a statute that has words where definitional things are left to the agency, in the past, you couldn't really challenge the definition the agency came up with, the interpretation and application the agency came up with.
Right.
And I would just add part of the reasons why this is so difficult to articulate specific examples is, if you guys remember the book that was written a while back called Three Felonies a Day, that talked about the expansive administrative state it is so expanded that the average American, violates 3 felonies a day because of these voluminous regulations existing in these administrative executive agencies that most people don't even know exist, much less that they are in violation of. And what this helps us get back to, whose job is it to create law? It is Congress's duty. And if Congress is going to create a law and create criminal and civil penalties, they need to be explicitly clear on what action they are actually regulating. Not leaving it up to an administrative state to come up with their own varying, ever-changing definitions, and then using that against defendants, both criminally and civilly.
Could this backfire, meaning that now the administrative state just like starts crossing all their T's and dotting all their I's, and I don't know. I'm just trying to think of like, okay, could this turn to really even hurt us even more?
It's hard to see how it would, and the reason I would say that is because it doesn't put the onus back on the administrative agency to dot the T and cross the I, or cross the T and dot the I. It puts that focus back where it should be, which is Congress, who is elected, who are supposed to be accountable to their citizens, to the people of the United States. Not someone sitting in DC getting paid $35,000 a year with a political science degree to regulate farming when they've never put on a pair of muck boots and gone out on a farm before, right? It's Congress who has the responsibility to create laws, to cross the T's, to dot the I's, not the administrative state.
So good question though. Like, as far as how could it backfire? I mean, an argument could be made. Congress passes a law, has vague terminology in it, and arguably the agency could come up with a very narrow, careful, very helpful definition for farmers, for small businesses, for landowners. So in theory, the agency could actually say, ooh, that language is pretty broad. That goes way too far. We're going to go very, very narrow, in theory. So there could be a scenario where Congress, passes a law that's sweeping, very controlling, and the agency is actually like, yeah, we don't think we should be going this far. This is going to be devastating. There's going to be nothing left to regulate. And Chevron deference could actually help. That's a hypothetical that's pretty absurd. I think in some respects, we just never see it going that way, right? Like, when do we ever see the federal government going that way? At least in the last 3 decades, it hasn't gone that way. It just hasn't.
So another question that popped up here: will this help any cases regarding the cases involving all the agricultural agencies? And if you can think of maybe a specific one that might come to mind, that's always hard on the fly. But I'm thinking of, just all the environmental regulations that farmers are now starting to face. What about, this just popped in my mind, all these regulations that are coming into car manufacturing now with diesel and adding all this emission standards, all that stuff, is that reversed now? I mean, when you go buy a new diesel truck now, versus a diesel truck 6 years ago, the new diesels have all these extra fluids, all these extra emission standards. They make things less efficient and more expensive. I knew of a guy down in, or I heard of a business down in Lewiston where you'd buy a new diesel truck, you would take your truck to his shop, and he would take out all the crap, that all the emission regulation, all that stuff. He'd remove it for you, and so you didn't have extra fluids that you had to put in your diesel truck. And anyway, I'm rambling a little bit, thinking of ideas. But any agricultural ideas that came to mind?
I don't know of any.
What about the problem. What about the Pennsylvania guy? The Pennsylvania guy,
right,
who was selling. He had a co-op. He had
that's right.
Online
that's right.
Yeah, no, that was what was jumping in my mind here in Pennsylvania, Gabe, is that case. So again, it comes down to a question of what words and languages and things are being used by the agency and interpreted unfavorably against that farmer by the agency to hurt them, that now the agency's not going to get deference, right? So things like co-op, there's so much in our society. This is what we forget. We all forget this. It's not just about the felonies. There are so many inefficient and wild things that we do in our society that come from government regulations, and we don't even realize it, right? Like, why do we even have co-ops? Why do we have buyers clubs? Some of that stuff is to avoid or to work within or to work around federal regulations. So again, every case, whether it's an Amish farmer trying to sell, unpasteurized milk in Pennsylvania to a co-op, to a membership-based thing, like what a co-op is, whether that falls under the regulation or not, whether you can do that, whether the agency has the authority to do that. Now we'll have an even playing field. We'll have a different standard. We'll have a better standard for courts to look at these. And you would hope to see, instead of the agencies winning over and over and over and over again, you would hope that the agencies would be reined in their rulemaking and their definition and their enforcement because of this.
Wow. I think there's a lot to work out here. I wish you could spend 2 hours longer. I mean, I just opening my mind and expanding my mind as we're talking through this right now. I know you guys got to run, but I want to get, if you guys have the ability, even if you don't have the ability, I don't care. What are your thoughts on last night's debate?
Oh boy.
Oh man, you want to start that one off, Davis?
Yeah, I'll start it off. Honestly, if it wasn't scary, it would just be sad. I mean, I really think the debate was absolutely what everyone had expected it to be, which is President Biden being really incapable of putting together and articulating clear thoughts that make sense. I had a very difficult time demonstrating an ability to engage in good decision-making, thought process, and things like that. So we all expected that, right? I mean, I feel like I'm completely out of it today because I got out of the hospital. Like, you wouldn't expect me to be on my best game today. That's the president of the United States, and it's not getting better. It's getting worse. Every week it seems to be getting worse, right? So it's sad in a way, if there hadn't been so much evil done by this man, you would think, let's take grandpa to the beach again. And, let's do those things. So I thought that was interesting. It felt very rehearsed. That's the only other thing I left with is when you have liberal political commentators saying we need to replace Biden within 2 minutes of the debate ending, felt very, very rehearsed. So I didn't get to see commentary on
I
it
want to
last
respond
night.
to that. I want to respond to that point, Davis. So here's my thoughts. You are 100% correct that after the debate, it was like every liberal commentator, including Hollywood, like Maria Shriver, were all coming out and saying, I like Biden, but his time has come. And we're going to lose the election. This is not good. So and it was incredible. Like right after the debate, and it was across the board. I mean, like I was listening to other podcast shows, YouTube shows. I kind of just took a sample of what everyone was saying. And they're all like, oh, Biden was awful. He looked, half dead. I mean, even the side-by-side complexion, optics. You have Trump looking very flush and healthy, and you have Biden looking very pale and like he's got one leg in a casket already. Right. And so even the optics of that was just like, what Democratic operative let CNN do that cut, right? The thing that I think is happening, and this is where legally I'm kind of, maybe you guys could help me here too, is this debate got moved forward. It got moved up to June. It was going to be later. It got moved up to June. And I want to think that was on purpose for this reason, that the Democratic convention is in August. And so you have to demonstrate, you can't all of a sudden get rid of Biden in October, September, something like that. You can't do that.
Right.
But the last chance they have to get rid of Biden is August. That's the last chance.
That's right.
But the problem is Biden has the infrastructure, the legality to have his name in every state, and Gavin Newsom doesn't. AOC doesn't, although she wouldn't run right now. But Gavin Newsom, I think, would be the likely choice. And so if the Democratic convention comes and they say, yeah, Biden's not our man, we're going to go with Newsom.
Right.
Then Newsom, can't he legally replace Biden on all the ballots if they do some sort of maneuvering in the convention to
Yes.
replace Biden, that's the only legal way. All of a sudden, Biden can now be on all the ballots across all 50 states.
Correct. Ohio does something weird called a presumptive nominee, but in every other state, the candidate who is selected by the delegates at the convention goes on the ballot. So the way this plays out is if Trump just resigned the presidency, Kamala becomes president, like under the 25th Amendment.
You mean
Kamala
Biden?
becomes president.
Not Trump.
Biden, right. Biden resigns on the 25th Amendment. Kamala becomes president. Kamala would become the presumptive nominee potentially as the serving president. But if he says, I'm not going to run again, like LBJ did, then Kamala's out of the picture, and that's how it moves forward. So I do really have to run now, guys, but thank you so much. Appreciate your patience with me, and enjoy the rest of the time.
Thank you, Davis. Caleb, I want to finish with you on this topic here. So as Davis said, so it sounds like the way you get on every ballot is actually from the state convention.
From the National Party Convention.
Right? Yeah, excuse me, national. Right. Yep, that's correct. Sorry. Thank you.
That's right.
So this really is a potential scenario here, and really the last ditch effort. I mean, they know they already have. I think the calculation for the Democrat Party is this: are we better off running Biden? Is our best chance to run Biden, or make a massive course correction at this point and run Newsome or whatever? It seems like I mean, both are high stakes decisions.
Yeah, so let me start back just a little bit. You know, part of my concern from a political perspective has been I've been concerned for some time that the Republicans framing Biden as old and decrepit as they have could potentially backfire, right? Because if you frame him as old, decrepit, can't stand on 2 feet, right, and then all of a sudden he can stand up there and talk for an hour like he did at the State of the Union. The State of the Union actually turned out okay for Biden because he exceeded expectations, even if he was below average, right? What the debate last night showed is that somehow President Biden is actually worse off than the framing led us to believe. And so, so first of all, let me just say that is terrifying. That you have the leader of the free world in this kind of mental state is an absolutely terrifying proposal. But going back to your specific question, the Democratic Party is really between a rock and a hard place. Well, here's why. Because number one, I mean, you can tell by the way the media is panicking. The Democratic Party believes right now, today, after this debate, if they leave Biden on the ticket, they're going to lose. Okay, so if you try to bait and switch him after the primaries, which he was completely unopposed in, at the convention floor, and frankly, right now, based on what the Biden camp is putting out against his wishes, do you fracture your own party? Because number one, you have completely subverted the entire candidate selection process within your own party. It's not as though that this is an acute onset problem that we could not have possibly known that Biden was struggling with these things when the primary started. We knew 2 years ago, we knew 3 years ago that his mental health was declining. And so you had the opportunity to run, Gavin Newsom, for example, to start that primary up 2 years ago as you slowly put Biden out to pasture. So the Democratic Party is between a rock and a hard place. If they keep Biden on the ticket, they feel like they're going to lose. If you replace Biden, you've undermined your own party's ability to select a candidate through a normal primary process. And then you get into the fact, who you going to pick? Because there are portions of the Democratic Party who are going to want Hillary Clinton and have a 2016 rematch. There are portions of the party. I mean, just like the Republican Party, the Democratic Party wants to move on. There's a big swath that wants to move on to Gavin Newsom, just like a lot of us wanted to move on to Ron DeSantis, right? Let the new guys take over and let's have the Florida, California debate that the country deserves. Okay, so if you select Gavin Newsom at your convention, are you alienating the Clinton fan base? You know,
No,
the two people who still believe in Biden. If you pick
no.
Hillary Clinton over a Gavin Newsom, are you now alienating that section of your party? That it
Uh,
is a real problem for them right now of how do you move forward if you're going to get rid of Biden, how do you move forward without fracturing the party? Because I tell you what, nobody on the Democratic side wants. Nobody wants Kamala Harris, Republicans or Democrats.
uh-huh.
Nobody, absolutely, no one in the world wants that ticket on either side of the aisle. Uh,
Uh-huh.
but if you don't give Kamala Harris the nomination, despite the fact that she's been VP, does that fracture a significant portion of your base?
Mhm.
It really is a damned if you do, damned if you don't situation for the
Yeah.
Democratic Party right now that they're
Yeah.
it looks like they're reeling hard and don't necessarily have an easy answer.
Yeah, and you can't get rid of the black woman.
Right, this becomes a problem.
Right. Right.
This becomes the problem. You have gender identitied yourself
Yep.
between a rock and a
Yep.
hard place.
Yep.
Um,
Yeah. It's funny because this is it's screwing the Democratic Party, their intersectionality, because Biden specifically picked Harris because she's a woman and she's black.
that was her only qualification.
Yep. And
Was it?
now everyone's cornered
That's right. That's exactly right.
because of that choice. Look
So
at
so what do you do?
God. Look
Do
at
you do you,
God.
do you so if you kick her off the ticket, let's say that you take a Gavin Newsom or a Hillary and you kick Kamala
Yeah.
off the ticket, do you have to bring in a Michelle Obama? Right?
Michelle's not going to run. She's too smart. She's
There's
going
no way,
2028.
right?
She's
Yeah,
going
there's no
2020.
way.
It'd be stupid to all of a sudden get into this hairy mess in
Yep.
2020, 4 or whatever. I mean, like she doesn't need to do that. She can cleanly run. Was my argument for DeSantis. I was like, do
Yeah, you and
not
me
get
both.
do not get into this, DeSantis. You'll have a clean run in 2028. But he thought he had a good chance. And it's the most difficult thing to come in and try to beat your own incumbent president in your own party in a presidential race.
Yeah,
It's insane. The only
I,
people
I,
that should want to do that are the people who want to grow their brand, and that's all they care about. It's like, hey,
Robert
this is just a
Kennedy
brand.
Vivek.
Yeah, that's right. This is a brand build for me. I'm doing this round. I'm actually really running in 2028.
Yeah, that's it. I mean, look, I have a theory about what happened to the DeSantis campaign, and to me, it's one of the absolute most frustrating things that's happened during this election cycle.
Yeah,
Because I do think that DeSantis had an opportunity, and it seems to me like he was undermined by his own team.
yeah,
Is the only explanation I have for what happened with the DeSantis campaign. But Obama were to run 2028, she has a built-in narrative, which is peace and prosperity of the Obama years. Which, by the way, anyone who lived through the ever-present recession of the Obama years knows that that is absolute nonsense. But that would be the pitch for them in 2028 of a return to normalcy and sanity and peace, prosperity. Like that's what she could run on in 2028 if she stays out of this
yep,
absolute quagmire
yep,
for
yeah.
2024.
Now, I think the only angle and the only saving grace that the Democratic Party has here, I would say in all the high risk decisions, this is the lowest risk decision. They're all high risk right now. Would be that Kamala remains VP. She campaigns on it. I need to be VP. She can come in as the savior. I'm gonna. We have to do it this way. I've been established in the White House. We got to bring a new president in because Biden is, he's having his problems, whatever. And so if Kamala played that role, that's the only saving grace. And I think in a way that they could slide in a new candidate into the process, and then Biden also willingly say, hey, I got to take care of my health and get out. And so they'd have to actually admit to the situation.
That's right.
Kamala knows that she's not electable, but she still remains VP, which is her best option right now. And then she comes fully behind someone like Gavin Newsom after everyone admits the scenario.
Yeah, I think the whole problem. And let me just add one thing. The cherry on top of that would be Biden stepping down and saying, "I support
Yeah.
Gavin
Yeah.
Newsom," right? Or "I
Yeah.
support this person," right?
Yeah.
That's about as smooth as transition as you can get.
Yeah.
But the
Yeah.
one of the important reasons that's not going to happen is because Kamala Harris is not that politically clever, um,
Or humble.
nor humble, nor is she going to uh, remain the VP to someone she sees as a rival, right? So
Mhm.
maybe you get that if there's a Hillary Clinton scenario because it's still, your boomer generation. They're
Yeah.
not rivals, they're not peers, they're not in the same age group. But for Kamala to do that with someone like, for example, like a Gavin Newsom, um, who's younger, more charismatic, more attractive, uh, a better political candidate than she is basically her waving the white
Yeah.
flag and admitting, "I'm never going to be president. I'm never going to have a shot," and that
Yeah.
she's not going to
Yeah.
have.
Yeah.
She's not able to do that. So
Yeah.
the only choice is chaos.
Yeah. I'm gonna talk to our listeners here for a minute. Any questions, listeners? Any scenarios that you think that the Democrats might have some sort of saving grace in the scenario? What are your thoughts? Put them in the comment section. It- you know, the way it looks here, also to me, I think one of the things that's so devastating about last night's debate is that even trying to rig the election is getting more and more impossible, because you can rig the election and it be believable that Biden won when you have COVID going on, when you have a president that is controversial, when you have, a president who's supposedly racist or whatever. You can kind of rig the election when the narrative is believable. But right now, the narrative is getting more and more less believable, that Biden can remain a president for 4 years and stay alive himself. And it's getting even less believable with the polls. I mean, like, it's the narrative that's really shifting from last night's debate, that I think even makes it even impossible to rig the election and make the election look believable, that it was legitimate. Does that make sense, Caleb?
Yeah, what really hurt us in the last election was ballot harvesting, right?
Yeah.
Where
Yeah.
you could just send out political operatives to go collect and harvest all of these ballots and turn them in at one
Right.
time, right?
Oh.
And one of my major frustrations right now is a Republican House and Republican states that have really done nothing at all
Yeah.
to eliminate, or let's say to implement 100% day of in-person voting. The European countries went away from this years ago because it's so fraught with peril. And we have done absolutely nothing to correct that issue.
Yeah.
But it does make it, I mean, my goodness, you still got to have people who, they take the ballot harvesting, for example. You still have to have operatives who go out and harvest the ballots, right? With this kind of narrative, are you even going to have people who are willing to do that again in 2024? It becomes I don't know if you saw some of the polling that came out of last night's, but the sharp, the Vegas prediction machine with the sharp divide over who's going to win the election. The odds went heavily in Trump's favor, and really, I'll be honest with you. Um, to me, this election did not look winnable by Trump as little as 60 to 90 days ago. It really didn't, because
Mm.
there was so much headwind um, coming out of the State of the Union address where Biden overperformed. Um, Add to that the fact that the Trump campaign was hemorrhaging money, and even as little as 60 to 90 days ago, did not have boots on the ground, did not have campaign headquarters set up in most of the swing states, right? It
Yeah.
really feels like we've hit a shift in the last 60 to 90 days. This debate only further kind of implements or solidifies that shift, but there's a long way to go. There's a long way to go to November.
Mm-hmm. Yep. No, so much can happen, as we know. Well, everybody, thank you for tuning in to this kind of CrossPolitic live to talk about the SCOTUS Chevron ruling and the debate. We have, we're in interesting times. It's funny what the news cycle is doing right now. The Republican convention's in July, the Democratic convention's in August. And honestly, I mean, this comes down to, our conference is Prodigal America, prodigalamerica.com. It's in Fort Worth, Texas, in October 31st through November 2nd. It is just days before the presidential election. Presidential election is, I believe, Tuesday, November 5th. Our conference ends November 2nd. And these news stories, SCOTUS rulings, the craziness in the presidential election, I think our topic that we've chosen for this conference is very prescient for our time. I think of Psalm 20. Some trust in chariots, some trust in horses, but we trust in the Lord our God. And that's the call of these kind of moments where God is really messing with our hair. But I think he's messing with our hair because he wants us to trust in him, not in Obama, not in Biden, not in Trump, and we get worked up in a frenzy around who's going to win in November. And I don't want Christians to be worked up in a frenzy on this. I want Christians to be thinking biblically, thinking wisely, thinking, like an oak tree when the wind is blowing. So prodigalamerica.com. I really encourage you guys. It's going to be in Fort Worth, Texas. I'm actually in Fort Worth right now. It's going to be in Fort Worth, Texas. And it is we got Steve Day speaking, Pastor Wilson, Pastor Toby, Dr. George Grant, Dusty Devers, Dr. James White. I mean, like the speakers, I think, are made for this moment. So I hope to see you guys in Fort Worth. We also do a pre-business conference at the end of October at the conference. It's the Thursday afternoon before the conference starts that night. Business makers. We got Kevin Freeman from the Blaze TV Economic War Room speaking. We got Darren Doan Agency speaking. We got Isaac Botkin speaking from T-Rex Arms. Great pre-business conference. There's just so much good content. Don't want you guys to miss it. Would love to see you guys in Fort Worth in October. So check it out, prodigalamerica.com. Caleb, thank you for joining us on the fly. I know it was an on the fly moment. Thank you for coming in, and hopefully I won't have to call you in any more SCOTUS rulings at the end of this week or this afternoon.
Well, it's been and I would just add to that, the one of the great themes that I love from the Psalms is that the wicked fall into their own traps.
That's right.
And so right now it kind of feels like we're watching that live and in person. So it's, being a good post-millennialist, there's always hope. But yeah, it's been a privilege to come here on here with you and talk about Supreme Court rulings. And thank you for the opportunity.
Okay. All right, everyone. Have a good day and get ready